Great to see everybody this morning. We're going to dive right into the next panel, which is actually, we're going to do 75 more minutes of just drill down more on demand curves. And just kidding. This is going to be on, the title of this panel is Building on Recent Antitrust Wins. I'm the moderator. My name is Lowe. I'm the head of public policy for Combinator. And I guess what we're going to do here is, the format here, we'll have a quick lightning round, and then we'll get into the questions more deeply. But in that lightning round of the minute or so, if you don't mind, just doing a quick intro of yourself, and then also any disclosures you have. I guess my disclosure is I kind of work full-time agitating for more scrutiny of the larger tech platforms to create some oxygen for little tech. And so that's my role in all this stuff. Not a lawyer, not an economist, but excited about this conversation on building on recent antitrust wins. So we have had some real liability wins, but the remedies are where momentum has dissipated. What actually counts as a win now? And that's what this discussion is all about today. Let's start here with Doha. Give us an intro, tell us any disclosures you have, and answer the question, name one win that matters most, even if imperfect, and why, in 60 seconds. And then we'll go down the row here.
Great. Thank you so much for the invitation to be here. I'm Doha Mekki. I am currently a senior fellow at the UC Berkeley Law School's Center for Consumer Law and Economic Justice. But beyond that, I'm much to the chagrin of my parents, basically a glorified antitrust gig worker, and basically spend all of my time agitating for a better environment for antitrust plaintiffs of all kinds. I testify in state houses and in the Senate. I help plaintiffs design better cases, help agitate for a better expert environment, and care deeply about these issues, because before that I spent 10 years at DOJ, first as a trial attorney and leaving most recently as the acting head of the Antitrust Division, where I litigated a lot of the cases that we'll talk about here. A win, though imperfect, is that we helped pare back the overreading of Trinco. And I'll leave it there because we'll talk about it a lot today.
Adam?
Hi, good morning. Nice to be here with you all. My name is Adam Gitlin. I am the chief of the Antitrust and Nonprofit Enforcement Section of the District of Columbia Attorney General's Office. My disclosures, I think if it's not me, at least someone in my office is probably adverse to definitely just about every entity designated a digital market gatekeeper. It would be easier to list. I think maybe Booking.com we don't have anything against at the moment, but I think everybody else has been designated a gatekeeper. I'm either in active litigation against or somebody down the hall from me is. And needless to say, my views today don't reflect those of the Attorney General necessarily. One win that I want to flag, even if it doesn't feel always like a win, or it didn't at the beginning. So the District of Columbia, as I'll talk about, has probably litigated more digital platform or digital related antitrust cases right now than other states. In 2021, we filed a lawsuit against, we're the first government entity to file a lawsuit against Amazon. I'll talk about this briefly. But in short, the theory of harm there was based on, in part, on policy Amazon had that was not necessarily written down as such. It technically did not impose a price floor, but it figuratively imposed essentially a price floor for third-party merchants that wanted to advertise on other platforms. We lost on a motion to dismiss because price floor wasn't written into the contract. And this is something you learn when you're educating state court judges who aren't used to some of these more complex concepts at the time. And that felt like a loss at the time because it really was. But on appeal, we kind of ran the table on Amazon and yielded for the first time, really, at least that I'm aware of, a substantive antitrust decision from DC state courts that we've since used to our success in other cases. And so since then, I think it has changed the dynamic of how we even think about whether or not we can bring antitrust cases in our courts, which for a variety of reasons can be better than bringing them in federal courts.
Austin?
Hi, my name is Austin Ostiguy. I'm an assistant attorney general at the Office of the Tennessee Attorney General based in Nashville. I'd like to first thank Alyssa and KGI for having me. This has been an awesome conference. Learned a ton yesterday. My role in the AG's office, I'm a line attorney and part of the Consumer Protection Division. So we tackle more than just anti-competitive conduct. We tackle unfair and deceptive conduct, UDAP claims, that sort of thing. My practice focuses primarily on complex litigation in technology and pharmaceuticals, primarily antitrust. So I do have my own biases. We have cases similar to Adam's Shop against Google, Apple, all the bigs. And so, yeah, just to get the disclaimer out of the way, these are my views. They don't necessarily reflect the views of General Scarametti or his office or the state of Tennessee. The win I'm here to talk about today, or one of the wins, is state and federal collaboration and enforcement. I'm pretty new to this area, but I get the feeling that this is an unprecedented time of collaboration, and it's sending a message to a lot of these big companies that, no matter how big you are, you're not above the law. And to have, the federal government bringing cases, but also 50 different sovereigns, I think that is a powerful tool, a very powerful tool. And so I'm excited to talk about that today.
Jason?
Hi, just building on that last point too, I just want to say that the collaboration, but also the learning from each other that we've seen across states, federal government, across the oceans on some very complex topics has been incredible. So Jason Kint, I run a group called DCN, Digital Content Next. I work exclusively for, and really we built this organization to be focused on the future of news and entertainment. And so I work for news and entertainment companies exclusively, big, small, from the New York Times to NBC, to Slate, to Vox Media, native digital companies, Hearst, et cetera. And so that's my disclosure. I'm a witness in some of the cases, and a room like this, a lot of people know me for strong views over the last decade on the concerns around competition and the intersection with privacy and data and the value there. And a lot of that's played out over the last decade. So you should know I took that job to kind of try to explain the real world of what's happening in the digital space and real concerns that came out of 20 years running and starting native digital businesses, basically, mostly in the sports space. So I saw kind of all this play out in the real world, if you will, including streaming the first Super Bowl timely back 12, 13 years ago. So back then people kind of understood in the rest of America what I did for a living, and now they don't as much. But anyway, I try to explain these concepts. In terms of a win, just kind of sticking to that theme of actual real world win, I do think the App Store cases, which are the furthest along, there's a real win there for the publishing community and news and entertainment creators, because Apple's no longer charging a revenue share at all. It used to be 15 or 30, depending on the nature of the transaction. It's will probably end up being something based on the appellate process, and then on Google's side, there's a settlement in play that it seems to be, it'll be somewhere between 0 and 9%, I guess I'd be fair in saying. And the difference between 0 and 9 versus 15 and 30 compounded for subscription relationships is just enormous. And so enough to pay for a newsroom at a lot of organizations, including local news. So it's a big deal. And the work on that's been incredible.
Thank you. Let's, Doha, start first with you. What are some of the non-obvious wins, whether we're talking about doctrine, operations, or coalitions? And what are the courts, where do you see the courts stepping away from Trinco?
Yeah, I mean, I think that one way that might not be obvious, how the sort of paring back of Trinco really was constructed, was that this was a really sequential effort that we started at DOJ that was really built through an amicus strategy. Before, Google Ad Tech was filed in January 2023, there were efforts to file amicus cases, first in the FTC and states case against Meta. That ultimately was not successful. But there was a case out in the 10th Circuit called Chase Manufacturing that was not digital at all. It was a case against Johns Manville, and it was about essentially a strategy to cut off a customer if it attempted to buy a product from a new upstart that threatened Johns Manville. And we filed an amicus brief essentially saying that is well outside of the doctrine in Trinco, which was about whether a monopolist could unilaterally sort of refuse to deal with a rival. And the court ultimately agreed. And it was very important just to establish even that very small decision, a very humble win, to get courts starting to read, Trinco as a very limited doctrine, because for years, really for as long as I could remember, Trinco was sort of held up in policy circles, in conference rooms, in Congress, in conversations that really mattered, as sort of protecting very large incumbents in digital spaces and very consequential markets as essentially protecting a large company's ability to do essentially whatever it wanted. And then cases like Allied Orthopedic, about product design, cases like, Amex really just seemed to calcify that kind of understanding. And so by the time we were designing cases like Google Ad Tech and could really construct complaints to get around the Trinco doctrine and to really focus on a broad course of conduct that was really about thwarting consumer choice, about leveraging vast monopoly power, that again was not about unilateral refusals to deal or even conditional refusals to deal, but again, broad course of conduct to really squash competition. Seeing that reflected back in cases was really important. And I should say Google Ad Tech was filed in the Eastern District of Virginia. And in the time between the Chase Manufacturing decision and the decision in Google Ad Tech, which came down in April 2025, there was a case that was decided in the Fourth Circuit called Duke Energy that cited Chase Manufacturing favorably. And so again, seeing courts start to talk to each other and repeat back the logic that was really carefully sort of laid, again, in non-digital cases was ultimately very gratifying. And again, you see it later, Judge Castell ultimately repeated back the logic, agreed with Judge Brinkema and the Ad Tech MDL. Ultimately, the Supreme Court denied cert in the Duke Energy case. And so again, we have very important precedent now in the Fourth Circuit. Nothing is safe forever, but these are hard-fought victories. And so the point is that really careful, long run, careful, methodical strategy can pay off. So that's very important.
Austin, kind of continuing this conversation about what we've won. The states really weren't considered heavy hitters 10 years ago. What, in your view, has changed?
Yeah, thank you. I always love to talk about the states, and I think we play a unique and ever more important role in this space, as I sort of alluded to. Particularly, I think we bring a measure of stability and continuity to enforcement, as compared to federal approaches that might change from administration to administration, and that's important. And the states also have specialized insight into the issues affecting our particular consumers, right? So Connecticut might be more focused on hospital mergers, Tennessee, music promotion, Texas, agriculture, right? And so it's important to have a relationship with your consumers and your businesses and understand what's really important to your state. And you'll see different states focused on different markets because of the unique impact on their constituents. And beyond that, we also have unique tools to get the job done. There's a annoying doctrine in federal law that holds that you can't recover for indirect purchasers, right? And many states have passed laws repealing, it's called an Illinois brick repealer, that sort of decision so that we can, in fact, recover damages on behalf of indirect purchasers. So one of the cases I work on is a massive generic drugs price fixing case. And the consumers are end consumers. And so, in the pharmaceutical supply chain, you've got the money going through multiple hands. And so it's important to have the tools necessary to reach the end consumer. We also have expanded relief options. We have civil penalties and we have disgorgement. And so when you bring cases together, you'll see a lot of multi-state enforcement actions. Adam's also talking about state enforcement, which I think is extremely important and can be very effective because multi-states can be clunky sometimes. But when you band together and a company sees that they could be subject to civil penalties and disgorgement from dozens of sovereigns, I think it makes a real statement. And one other thing I'd say about state enforcement is that it's a wonderful area of bipartisan collaboration. I think, working on antitrust and consumer protection issues, they are harms felt by consumers in all states. And so you really see through the National Association of Attorneys General a shared vision and sharing of resources in across party lines. So I'll talk a little bit about the Google search case today. I was on the trial teams for liability and remedies, and that's a great example of cross-party collaboration. Attorney General Phil Weiser of Colorado collaborating with my Attorney General, Jonathan Skrmetti, to, take Google to task. So I think that's an important service that the states can offer in this area.
Jason, can you talk a bit about, from an industry perspective, you pushed these theories of harm before the government was ready. What did that take?
To echo the point on the states there too, the education piece of simplifying the discussion, which at that time, 8-10 years ago was around understanding the importance of data, understanding the growth of the advertising market and how much was really going just to two companies. And that was problematic, that 80%, 90% of the incremental growth in advertising was going to Google and Facebook. So just simplifying the discussion and then starting to understand and explain the technical needs for kind of educating on that. One thing that from the state perspective that I recall that really kind of, up until probably 2018, 2017, I was regularly told like the enforcers will never really understand this. It's too complicated. Focus on Capitol Hill. And much of our work, believe it or not, is actually not this piece. It's actually research and best practices and learning from each other. So I was kind of living in rooms where, I was seeing the problems, but then I was trying to figure out a way to make a difference. And when Texas started filing its CIDs with Google on the ad tech case in 2018, and I had a chance to look at those, I thought, oh, wow, okay. The right people are asking the right questions and they understand this business. And that gave me a lot of energy. And I think I translated that to other people. And, that came from a few academics that were writing really good white papers, Fiona included, on the Google stack. And I think they started to really understand things. And then that built from there. Australia, a report on the ad tech marketplace, the UK report, like everybody started learning from each other. And it was truly bipartisan across governments, and that built energy, I think, and confidence. But it's, they were right. They would take a long time in the courts. So here we are.
Well, it seems like the mood here is pretty upbeat, but I think I want to change it to, I think let's snap out of this here and get to the crappy parts, Doha. Is the root cause that judges just don't want to be regulators?
The root cause of what?
The root cause of these remedies, basically that when we saw in the Google case, Judge Mehta had this incredible guilty ruling last spring. Everybody was doing somersaults. It was a similar type of optimism and exuberance we've seen the first few minutes of the panel. And then when the final remedy ruling came down, everybody said, what the heck happened? And so maybe you can unpack that a little bit and talk about what you think is going on with judges. Is the issue here that they just don't want to be regulators and that we need some kind of sectoral regulation? Unpack that for us.
Yeah, I feel like we have to be honest with the audience. We promised to be like a little cheery
Yeah.
at the state of competition in digital markets. So I appreciate you're saying we were exuberant. We tried, or at least I tried. So look, I mean, just to summarize wins, like the Sherman Act is still with us. Some wins on Trinco, some wins, protecting against overreading of Amex, some wins related to aggregation doctrine. The cases got filed, right? Still very proud of that. A lot of them look like they're going to go to trial, we hope. I think the remedy decision in the search case was like, the first big sign that there are some very serious problems. I'll try to tick through some of the big ones that I see. I think the first is, there's sort of a failure to follow just the requirements of the law. Remedies law is fairly well specified, and just basic requirements to terminate the unlawful conduct do not seem to have been laid out in the remedies opinion. I think it goes without saying, like, I have no clients. I very much speak for myself. I'm very glad that the United States has filed a notice of appeal of the remedies decision, and that a number of states appear to also be appealing that decision. I think there is too much of a focus on dynamic competition without adequate study of the market. I think there are a number of events that you can see just in the past year that seem to undermine the logic of the remedies decision. There is sort of a lot to be learned from what has happened here. I think it's too soon to say what sort of what the policy, like, sort of remedy is, but I think the Court of Appeals is going to need to step in. It is closer to time zero than the end, right? There's going to be briefing, there's going to be argument, someone will be unhappy with that decision, there will be efforts to file a motion for reconsideration, then there will be en banc review. I'm sure something will go back down. I mean, we all kind of remember the circus that was the Microsoft decision, and I think we have all had a sense that at the end of the day, 9 justices may well decide the outcome of these very important antitrust cases. And maybe then we'll have some clarity about, like, what's going on with Article 3 courts and how comfortable they feel making big decisions about important antitrust cases. In the meantime, I think there probably is some learning for enforcers, whether we're talking about public enforcers or private enforcers. Having had some opportunity to study this, and I should say I was a counsel to Donald Trump's first head of the antitrust division and principal deputy under the Biden administration, and so have seen how people with very, very different political views have thought about this issue. Going back to, like, early, like, thinking shortly after the Microsoft days, there was a very considered decision not to heavily regulate the open internet and let it flourish, right? And I think there are a lot of benefits and like positives that consumers, like, really received from that decision. That being said, there were anti-competitive market structures that likely calcified due to the failure of antitrust enforcers to intervene. And I think that some of this, some of the events related to Google search probably have made it very clear that the difficulty of breaking up all of this monopoly power later on probably necessitate earlier intervention. And so it seems like you can either be more interventionist in terms of mergers, in terms of filing your monopolization cases earlier, or you can have the heavy hand of regulation, right? I mean, most of us who grew up like under the agencies sort of think of antitrust as an alternative to regulation. I think more thinking has kind of disabused us of those binaries. And I think there's just more research underway to sort of, maybe introduce ideas for like better regulatory design.
Can I jump to Austin on the role of kind of time as a weapon, and how are we rewarding defendants for slowing litigation?
Definitely. And Doha was making me think about bringing these suits earlier. That's something that I've been wrestling with for the past few years. If we highlight the FTC versus Meta case, when I first came into my office, the states, I watched the oral argument of the New York Solicitor General on a, dismissal on laches grounds for the states, which basically meant the states sat on their hands for too long. And now I look at, the FTC's case getting booted on market definition. And I don't think, and so the court was looking at the market as it stands today, and that's very difficult because when they brought the case, TikTok wasn't what it is today, right? These markets are extremely dynamic. And so you run the danger by relying too much on pre-suit discovery and hemming and hawing and wondering what to do, that you are going to bring the suit too late, whether it's too late for the 4-year statute of limitations under the Sherman Act, or it's too late for the market that's changing extremely quickly. You see this in Google search too, right? Generative AI is starting to erode the search market, not replace, but erode. And so this is something that enforcers really need to grapple with in terms of when to instigate a case. And then also, as you mentioned, Luther, making sure the case stays on pace, right? Because what is a win in these cases if we get it 10 years after the filing of the complaint?
Jason, what was your reaction to Judge Mehta's suggestion that it felt like we were like, and I definitely saw it at Y Combinator, just that's last summer, just the exuberance over AI, and talk about sort of the role that you think that may have played in Judge Mehta's decision, him essentially saying that, oh, well, it seems like AI is going to fix all this. And do you accept that? And why or why not?
Don't accept it at all. I felt like he forgot about the liability phase at that point, because a simple example from the liability phase, he learned about and really understood, it seemed, the importance of the scale of queries and clicks from search in terms of teaching its search engine in a way that, number two was whatever, significantly smaller, Microsoft, and that was a huge advantage to Google, and that all applies to the AI world. And so when he made that decision that, or put out his opinion that the AI world was changing things, my reaction was, well, now Google's going to unleash their advantage that they have, particularly with what they call tail queries of, this directly affects news companies, because every day, like something like 15% of the searches are things that we've never searched before, ever. And a lot of that comes from our world of media. And Google sees that at scale that no one else does. And that's really important to grounding AI too. So we're watching it unleash, and, including the way that and I know there's a lot of people studying how AI overviews are impacting things, but I mean, it's decimating a lot of the publishing market. And so disappointed. I was also disappointed because there weren't really any, and he noted this, there weren't publisher witnesses at the trial. You can, look at that from a lot of different ways, but I will tell you that back, 7, 8 years ago, I told the enforcers that your hardest challenge is going to be, and probably your most clear evidence can be no publishers are going to want to testify and get pulled under the light against Google because they're by far the most scary and concerning partner out there. So, so publishers didn't testify too. So,
And it seems like, Doha, you let me know if you disagree with this, but we read a couple weeks ago that Apple has now essentially handed the keys to Google to let Gemini power their, they've sort of thrown in the towel. Siri is sort of embarrassingly stupid and has been for years, even though we've had LLMs for over 3 years. They've handed the keys to Google. Do you see that as a reflection of basically that's the green light that Judge Mehta has given these companies? Is that a direct result of the remedy?
Totally. For the record, I don't think those are your words, not mine. I don't think Siri is embarrassingly stupid, but I do think that allowing Apple to sort of integrate a Gemini-based model into the iPhone just looks a lot like the default deal that was like at issue in the Google search case. But I just have to say, I was not at DOJ during the remedies trial, but some of the documents that came out during the remedies trial, I think really speak to the strategy here, and I think just make the logic of the remedies opinion more mystifying. So, during the cross-examination of a Google witness, a DOJ lawyer showed a Google vice president a document meant for someone at Google DeepMind, where someone had mused about training a Google AI model that would become Gemini with a wealth of search data, right, to improve it, right? There was this thing called Bard that was horrendous. And right, it was eventually sunset, and Gemini is quite good, right? And like ultimately, it was we understand that it was made better because of Google's massive advantages in search, which again were the core of the search trial. And so during the trial, it sort of came out all of the ways that advantages in search and also just inputs that come from search sort of give Google a leg up in AI. And so again, this idea that AI would improve search just sort of has it backwards, right? It's monopolization, monopoly power in search would sort of risk making that the high watermark of competition in certain foundation models. And I think that's the point I made earlier about betting too strongly on dynamic competition at the foundation model layer in the remedy opinion without sufficient study of competition there.
So there's been, there's sort of a view out there, I think, that we should just give up on the courts. And Adam, I want to turn to you now to make the other case. Judge Donato in Google Play imposed serious relief, and he's holding hearings because he's worried it's not enough. So what should we take from that?
Yeah, right. So I'm the person who's supposed to bring you back up from the slump. I take issue with the notion that it's all kind of doom and gloom for a couple of reasons. One is because I think there are some really good decisions coming out there, and they are part of this dialogue that Doha was talking about earlier between judges. It also is something that litigants are then using to their advantage. This was even before the Google remedies phase in the search case. We were dealing with injunctive relief in the Google Play, or what we would call the Google App Store case. And Google was arguing that remedies, that the sort of the Trinko analysis in general, that the duty to deal with rivals and the fact that it shouldn't have one basically extends to the remedies phase, and that we shouldn't have to do that. And Judge Donato used a phrase that we've since been seeing in briefs in other cases, that whatever Google's Trinko vibe that it was detecting might be available to it just doesn't apply, or certainly doesn't apply in the same measure in the remedies phase. And that's really important for those of us who are also thinking between, well, in which basket should we put our eggs more? Should it be ex ante regulation, or should we try and bring a good, strong enforcement case? And if we win, push for remedies. And the second kind of related point is that the difficulty that we face as antitrust enforcers, and that also legal academics who study antitrust also face, is that we don't get a lot of data, right? We get data from, like, if we're lucky, a half dozen judges in a year, and it tells us something about what they think about something. And there are hundreds of federal judges, and most of these judges have the opposite of the last say on the matter, right? So there's a real, I think, danger in over-interpreting what the zeitgeist is based on what you hear from one federal judge, no matter how careful their opinion may be, no matter how deeply they've studied the issue, no matter how right they think they may be. So I want to caution folks against sort of overreading in a way that makes them, unduly discouraged, particularly because we're in an environment of increased enforcement. Doha, made reference to the existence of private and public enforcement. As somebody who has spent time doing enforcement for the Department of Justice in the plaintiff's bar and in state enforcement, I love the fact that there is constantly, I mean, Fiona can't write a paper without plaintiffs bar members basically turning it into a lawsuit within 2 or 3 months. They just have to figure out what the facts on the ground are to get past a motion to dismiss. There ought to be, to Austin's point, something in between the years-long traditional approach that the federal government has taken and the weeks-long approach that we sometimes see in some other corners of the bar. But the fact that there's this multitude of lawsuits happening, I think, if anything, helps, because it means we get to hear from more judges.
How do you decide when to move? What is the happy medium on speed between when the plaintiff's bar files over the weekend versus the government taking 3 to 4 years?
So I think it's case specific. We've brought cases relating to tech platforms after less than a year of investigating. And I think obviously it's going to depend on what you're talking about. But of course, in digital markets, it's even more important in a sense to move fast, because before you know it, you're essentially litigating the fix. You are on the ground having to deal with changes in what the conduct actually is. But that's very different from some of these 3-4 year investigations that led to some of the actions that we've seen in the last few years.
DC was first on Amazon, first on RealPage. What makes you willing to move before the feds?
I don't know. I think they sometimes move first, and we generally try and talk to them if we know they're looking at the same things we are looking at. There may be some advantages in, for depending on this goes even beyond digital markets to questions of whether or not we have a pretty narrow geography. Gathering evidence is a little faster than if you're doing it for 300 million people. But there are also a variety of different mechanisms that we can use to leverage the work we do. So we have a relatively small staff. I try and complement that with things like partnerships with federal enforcers, using contingency-based litigation to work with plaintiffs' bar firms. That allows us to simply bring more cases. I supervise them just as much as I supervise those brought by my team, but it just adds lawyers, and frankly, it helps deal with the incredible costs that are involved in bringing antitrust litigation.
Tech giants don't necessarily have a home state. I mean, I guess you could argue California, but also they sort of try to put themselves everywhere in the same way sort of defense companies used to do and so how does that shape the coalition dynamics? Maybe Austin can comment on that as well.
Yeah, I'll just say, obviously there are going to be some, Austin put it well earlier, there are going to be some industries that are simply a greater focus than others. But I do think one thing we see a lot is there will be increased state interest as soon as consumers are the most directly, seem to be quite directly harmed. When it's more amorphous, that tends to be harder, because particularly if we have these sort of products that are available on a nation, or services available on a nationwide basis, it's not clear where the disproportionate impact is across a particular geography. You actually see that, I think, in Europe as well. But in our cases, we will often work together and pool resources, even understanding that some states are going to invest more in every respect than others.
Yeah, and under our laws, if you are conducting your business in a way that's harming our consumers, I don't care where you're based, we can reach you. You know, California has an economy the size of Germany. You know, they have a duty to protect those people. And, you know, I wanted to turn back quickly to what Adam was talking about, this issue of timeliness and keeping the pace in these litigations. And we're starting to see cases I've seen in DC, Tennessee, Ohio, individual state cases, and you're more flexible that way. And you're not fighting perhaps different interests across sovereigns, different theories of harm, right? There's always disagreement about should this be a consumer protection case or an antitrust case? Which angle should we take? Which is the most supported by the pre-suit evidence that we have? So I'd love to see states going out on their own. And one good example of this is the consumer protection case that many states have brought against Instagram for the way that their platform harms young people and is targeted towards young people. You're seeing a multi-district litigation formed on the West Coast, but you're also seeing independent state cases, Massachusetts, DC, Tennessee, and we are able to move quickly. And we are able to, you know, we're able to make a real change, and the companies are starting to fight on so many different fronts. I think it really sets them off balance. So there's a time for multi-states, and there's a time for single state action.
Just on the timing question, just to throw some optimism back in the room too. And your question about do courts really want to regulate, I think is a reasonable one too. The ad tech case really is, to me, the bellwether. Like, one, Judge Brinkema very clearly understands the conflict of interest. Structural separation is a very clear solution there. The conduct was within where the harms, and I mean, the conduct was within the same market, the tie, et cetera. So unlike the Chrome divestiture, et cetera. So like, that's imminent, and it took just a couple years to get there. And the states, as soon as the remedies orders out, are going to resume. You got the private cases in New York. They've actually adopted Brinkema's findings of liability for, at least for the smart narrow case they took on in Virginia. And, you know, I think outside of maybe one or two things that are still out there in my mind that haven't been explored enough, it's been a home run. And so I don't want to lose sight of that piece. And that's what fuels most of digital media, is the advertising marketplace. And so if she decides just to go with behavioral remedies, which I am more optimistic than most on structural based on what went down. And if she decides just to go with behavioral, she's going to be in the business of whack-a-mole. I mean, Google's already reversed course on one of the key pieces of conduct in Virginia because of pressure from EU. And they did that super quietly in December, almost like they just wanted to do it and say like, that's no longer happening. So she needs to do structural separation. If she doesn't, then I'll have a very different attitude the next time we get together.
Yeah, I mean, that case started a bit, I was concerned by the gimmick that they used to get the jury, turn it into a non-jury case. And we had a conversation with Adam last night about some of the, how that compared with the Live Nation Ticketmaster. Maybe talk about that for 30 seconds, if you don't mind. I think it's fascinating.
Pending litigation. What do you want me to say?
Oh, that's right. Sorry. Never mind. So let's talk about if courts don't always
try and keep it really, really focused.
Well, maybe we can talk. I guess I'm trying to not. I guess we can't. You guys can't be super specific. What is Austin, is there an example of a time when state and federal collaboration, what does it look like when it breaks down?
You know, I was prepared to talk about how it works very well, but there are breakdowns. I mean, think about even just the states litigating together. There are, even aside from political differences, agendas based on what your consumers are demanding from you. There's going to be differences of opinions. But honestly, I think what we have experienced both with the antitrust division under Jonathan Cantor and now under Gail Slater is a breakdown in or differences of opinion don't result in the breakdown of a case or a split. So look back at the Microsoft case, you had different appeals. You had a states only appeal, right? But here we've seen now in the Google search case, the states coalition and the Department of Justice unified in noticing a cross appeal. And I think this really speaks to the antitrust division's staff. And they're incredibly intelligent and experienced, and we're all learning together about how to handle these new markets and these ecosystems. But there's humility there, and there is a consistent open channel of communication and real discussion and debate. And so I think that's what, that is a real win in my book. And seeing it stay consistent across administrations. I mean, this is how we are able to bring these great cases and stay aligned on strategy and really bring the full force of our abilities to bear and protect our consumers.
What it's worth, I mean, a
Okay,
big
go ahead.
part of my job was whipping bipartisan support to join our cases, and that was awesome. And in Tennessee, I mean, General Scrimetti is awesome on antitrust issues. Like having filed both Google Ad Tech and Ticketmaster, like he was a great friend on those cases. Like we filed agristats with General Paxton. I cannot imagine we agree on, I don't know, something between 94 and 97% of issues, but on antitrust, he is a great friend. And so I really appreciate Austin's comments because I think the staff of the antitrust division, they are really wonderful. And I think there are examples, there's one example of the feds actually signing on to a state case in Ohio versus NCAA. And that was a really great outcome for the country with college athletes eligibility. And so I think that's something that works really well across cases.
Great points. So let's talk about what's next now. If the courts won't always regulate, then what's the path? Are we gonna do legislation? Is ICOA coming back? Are we gonna do sectoral regulation? We're gonna create sort of a FTC, but for tech markets, DMA style pressure. What do you think's next? Why don't we start, Jason?
I mean, specific to ad tech, there's a bill called the America Act that Lee and it's very bipartisan. Everybody was on board on. So, but I think they've been waiting kind of to see what the courts are going to do. But it will, effectively solve the Google issue, but it'll solve the rest of the market issue where you can't be too big on both sides of the transaction.
Do you think that the sense that the courts have not kind of gotten the mission done is enough of a political forcing mechanism for Congress to actually do something?
If Brinkman doesn't do it, then I think that's very much going to be something that'll accelerate that. Because I think the Congress very much, Lee's had multiple hearings. I think he very much understands the problem, and it translates from the finance sector too, that if you've got real-time auctions happening and somebody's got market power on both sides, a legal monopoly power on one side, like that's a problem.
Hope you're right. Austin?
But that would be the only thing.
Yeah, I haven't given up faith in our courts. And like I said, maybe if federal courts aren't getting the job done, state courts can. On legislation, I'm a little more pessimistic. This concentration of private power translates to excessive political power. So what are you going to do there? And I find it hard to believe that we could, and maybe I'm wrong, implement something like ex-ante regulation here. I think there's another path, and kind of being here has inspired me to think about it. The research and the conversations about this area, about competition in digital markets, and having people come together and write papers and have discussions and put articles in the press and have this base that judges can understand, that the nation can understand really what's going on, because I think there's a lot of, we're still sort of hanging on to, Chicago school ideals. And if we can have more people talking about how that's not worked, what could work, right? There's a lot of questions still. So I think the discussion, a public discussion, just needs to be happening. And I think that makes more of a change than people think.
Adam, states are doing ex-ante regulation in the form of PBM laws. Is that the future?
I don't know, but I somehow doubt it, at least with respect to digital markets. That is, there are certain kinds of sectors that are more susceptible to state-based regulation. Healthcare is one of them, and many states have for a long time had, and some are now even adding, ones that relate to, for example, hospitals and hospital mergers, and some of those consider factors that go well beyond antitrust, but do consider competition issues. I think it's a little bit trickier on digital markets, particularly because their borders aren't always clear. And so there's almost always, you can already see that there have been some efforts at the state level to pass regulations relating to artificial intelligence, and there are already essentially federal efforts to stop them and to preempt them. And I think that seems like something that is likely to happen, because it is hard enough for people at the federal level to agree on what might be the kinds of regulations. If you look at, you raised ICOA, right? Just the discussions that happened there, even among people who at a high level agreed about how we would identify the gatekeepers, basically, to grab the DMA analog, was extensive enough that one could reasonably be a little bit skeptical about whether or not you're actually going to see at the state level something that where folks can be educated enough, to get to Jason's point, and also agree upon. So I don't see a lot of it coming down the pike at any time soon, at least not in the same way that you would see antitrust enforcers continue to keep pushing the button.
Doha, look into your crystal ball and tell me what's going to solve this if the courts aren't.
So look, on the courts, I think we need probably one or two more decisions to see, I don't know, like real momentum, or just a direction in one way or another. I'll be excited to see what happens in Google Ad Tech. And I will be excited to see decisions in some of the real page cases, for example. And I have to say, not all state legislation is the big stuff, like search and ad tech. They are moving on algorithmic collusion. They are moving on age verification. They're moving, sort of the other kind of consumer protection-y things. But the algorithmic collusion stuff is real. And I think more states are going to pass laws, right? Like anything that can be geographically bounded where they feel like their consumers are being hurt. They're not waiting for the feds. And there are preemption efforts, but so far they've stalled out. And I think as more people become aware of these economic pain points, I think it will be harder, frankly, for there to be preemption, because people are upset and they're frankly concerned about like some of the job loss stuff and like the zeitgeisty things are operating on people. So I would sort of be curious how that plays out politically. In terms of what moves things, I mean, I think Austin makes a powerful point, right? Like some of the power in markets drives political power, right? And so I will be curious what actually moves Congress to do much of anything. I think we're in gridlock, unfortunately. I think there are much bigger issues happening in the country. I think all of us like to think about antitrust and consumer issues, but it's just really hard to think about that in isolation and not really, really big macro pressing issues happening in the country right now. So I think antitrust might be at the kids' table right now.
Jason, you want to say? You
No.
poking your head out, and I'm going to call on you. Okay, good. So let's, I mean, I would say the thing that, really this panel, the title, Building on Recent Antitrust Wins, I was pretty nervous kind of coming into it and until, some breath of life was given to me in the form of the cross appeal a few days ago. Austin, you want to talk about the significance of that, what that means? What does that signal?
Yeah, I want to be sensitive about, ongoing litigation. No, but I think one big point, and I've mentioned this before, it is a cross appeal between dozens of sovereigns and the federal government. There is a shared message here, so, and I think that's an important factor, and we've stayed together throughout this entire litigation. It just turned 5 years old a few months ago. So, I think both ways about it. In one way, I'm very excited to continue the fight. I love fighting for things that matter, and we'll see where that goes. But at the same time, part of me is like, we brought this case years ago, and now we're going to go through an appeal. And God, I mean, why wouldn't Google go to the Supreme Court? They've got more resources than God. And at the end of the day, what do you win, right? And so at the same time, we have a duty here too. We look at the remedies package, and obviously it differed a lot from what we had proposed. And obviously a cross appeal signals that we think that there are issues that we would like that we feel it's necessary to push on. We're not going to take no for an answer. But at the same time, I am concerned that what's this going to look like in the end? What good have we done?
All right, we're about to turn to Q&A here, but I just want everybody to close with one sentence. And the sentence is going to start with, building on recent antitrust wins means blank. So who wants to go first? Jason, why don't we start with you? And you can pass if you want.
I'll pass. No, I'll just in the spirit of, it means significant work. I can't emphasize enough, at least when I showed up in DC 10 years ago, and really the only action was in Europe, how, there was a halo over these companies and there was no activity, no understanding, et cetera. And so the fact that we're talking about wins and remedies, there needs to be energy and there needs to be bipartisan collaboration and there needs to be work across oceans to build on that. And the people in this room and in your space can do that. One sentence.
Building on recent antitrust wins means looking at all the wins, right? We've heard from everybody here today about it's not just about court decisions. It's about the discussions that are changing and not being so lopsided anymore. It's about small wins that might not be on the front page. So just keep an open mind and fight the good fight.
I think building on antitrust wins, as my comments earlier, it just means patience, but not too much. We still, as enforcers, are, to go to the earlier question that you asked, Luther, about sort of like how long is too long to wait, or how much time do you need to do? Government enforcers, realistically, when they sue, are going to be expected to have developed fairly comprehensive economic theories behind their complaints. They're going to be expected to have detail. Judges know we have pre-suit subpoena authority. We can't just kind of put some stuff on paper and go right in. That doesn't mean it has to be very long, but we need to, we can move faster, but still understand that credibility is pretty much everything when you're litigating, and that we need to be thinking through the cases we bring, being as current as we can on the economics, and mindful that just because here and there's something that doesn't feel like a win in the moment doesn't mean that we can't use it to our advantage down the line.
I think building on recent antitrust wins means actually filing and litigating a lot more cases to verdicts and judgments, and applying the law as written, and reining in a lot of the evidentiary and spoliation issues that we're seeing in these cases, to include sanctionable conduct by very large companies that in many cases seem not to believe the law applies to them.
I'll do a stab at this too. Moderator's privilege. Building on recent antitrust wins, I think for me the back to the back and forth, Jason, you and I had about does the court's failure put the ball back in Congress's court? I hope so. I think that we do have some more political energy, and I think that the rise of vibe coding and the cost of creating software going to zero is giving even more political energy, because we have, we're in a situation where 20 years ago, it was very easy to create web pages and web sites with the rise of, HTML based editors. But the difference between then and today is, and by the way, that created the open web, and it caused an explosion of services and content. We're in a similar situation today, except we've got these bottlenecks in the form of the worst DMV in the world, in the form of the App Store, and Google that, unlike 20 years ago, diffused 100% of that web, that traffic to the web. Now, as a baseline, keeps about 70% of it. And so I think that is, so if we really want the fruits of AI to touch consumers, we need to, deal with these concentration issues. And I think that creates political energy. And so I haven't given up on Congress. Let's turn to Q&A. Any questions?
I had a quick comment and then a question. I guess we talked a lot about the law of remedies, right? It's like there's liability you can get, but then when the remedy phase starts, it's kaput. I guess so courts talk about how they have a lot of discretion to craft remedies. They can terminate the illegal monopoly. They can deprive the defendant of the fruits of the monopoly. But in reality, there are some limiting principles around the remedy has to be tailored to fit the wrong. There's rigid causality requirements. I remember in the Judge Mehta's opinion about Chrome divestiture, where he's like, I can't do Chrome divestiture because maybe Google benefited from its illegal payments and so it could create Chrome, but I can't tell how much of that was because of the legal payments, so I'm not going to do the divestiture, right? A lot of that goes back to Microsoft and some really bad case law. And in the context of digital markets, there's a lot of uncertainty around where the technology is going. So if the standard is grounded in causality, how do you educate judges around the uncertainties of technology? Then how do you request remedies that can move the case law of remedies in a better direction to give them more freedom to implement remedies in digital markets?
So I'll take that in the first instance, since we proposed the first set of remedies there. So Having a lot of freedom to design remedies is just that. They can take in a lot of education to achieve the like pretty well-defined goals that are sort of set out in the law for what an antitrust remedy must do. And I think that Judge Mehta, to his credit, was very good about asking the litigants for education about how the product markets worked during the liability phase, appointing a technical committee, for example. And so courts that retain jurisdiction can appoint experts of all kinds to continue to take in information. But if you recall, the proposed initial remedy was sort of staged, right? So it was, it set out like a series of behavioral remedies, and like only if they failed were there like divestitures, right? So there was like a stair step, or like a ladder system of proposals, right? And the vast majority of those were rejected. And so, in terms of like remedy design, there are just all kinds of ways that you can kind of set up a regime to, incentivize good behavior, to take in more information. DOJ and FTC can amend judgments all the time. If something is not working, parties get hauled back into court. And so, there's nothing kind of like unusual about consent decrees in that regard.
I'll just add on that agreeing with everything Doha said, but also saying that where appropriate, I think some of the things we've been talking about with respect to speed can apply to remedies as well. I favor disclosing remedies I want as early as possible in litigation and actually seeking them as early as practical in litigation. In antitrust, it's rare, except in the merger context, but in other areas of litigation, it's not unusual to see the government file an affirmative motion for summary judgment that basically, that the economists, right, this means we're asking the court to determine that no reasonable jury could really disagree with me on the liability point, and ask for the remedy all in the same submission. So this is before we've even gone to trial. Basically say, Judge, the evidence here just stacks up way too much in our favor, not only in terms of what law was violated, but in terms of what's the solution here. And we very often win on that. Now, obviously, it's not necessarily going to be as easy in antitrust cases with fast-moving facts, but it may be easier to start signaling early what kind of remedies you want, so that the facts have not changed so much by the end of litigation that it becomes unrealistic for the court to consider what you were asking for in the first place.
One comment and a question. So the comment is, I think it's important to be legally creative here to deal with the bottlenecks of some of the precedents we have. I mean, in Europe, for instance, we also had an essential facilities kind of Trinco precedent in the Oscar Bronner case. What we did, actually, we developed a different concept of access to interoperability or access to, data. And in a very recent case, the Android Auto, basically the court opened up possibilities to bring such cases without passing by the very difficult requirements of the European Trinco, which is Oscar Bronner, concerning indispensability of access, right? So, and obviously that will happen with, strategy of litigating and developing different narratives than the narratives of the past, to a certain extent, to be more creative. And that's the comment. The question I have is, how do you think it's possible to develop interoperability regimes or which are sector specific as a starting point? I mean, we have now the European health data space regulation, which actually opens up, the digital health space and develops an infrastructure of interoperability. We have in the past, open banking, open finance initiatives, right? In the US, I guess you have this One Health regulation, which is not really about interoperability, it's more about data portability. Open banking, I have no idea, if this is something that has developed. It's more like a consumer protection issue rather than a competition antitrust issue. But wouldn't that be interesting steps forward, these kind of sector-specific regulations that will develop the law to enable to move further to more general applications in terms of interoperability and access to data.
Anybody want to jump on that? I mean, I think on open banking, there's been sort of a false start. The Trump administration sort of tried to roll back the 1033, and now they've kind of paused, and now they're sort of back in discussions about the fate of it. How about any of the other sectors?
I would just say, when I think about what is the analog to Oscar Brunner in the US that I see in the developing in the case law and also in tandem in regulation, it goes back to actually the question of how ecosystems develop, which is, generally speaking, in the early days, because there isn't so clearly always a dominant player, it really does rely on separately owned firms to work together, right? And then that it has certain implications about the profitability of working together. Even this line of Trinco cases in the United States acknowledges that we ought to be suspicious when a dominant player stops doing something that was interoperating or otherwise working with a competitor or some other third party that was previously profitable, but that now, for some reason, they seem to be willing to leave on the table, right? Because it's irrational for them as an economic actor, and it's weird because we knew that they had not elected to simply go it alone all these years earlier. And I think that is, I mean, we see this outside of tech too, the Seventh Circuit via media case that's been going on for a while. The reason those folks got around Trinco really because they knew that their plaintiff, this is a cable competitor, but essentially had previously worked with the defendant. And this is an argument that has been made by the government in some cases and is also animating some of the legislation we've seen at the federal level, that what they're trying to get at is, if there's an ecosystem where everybody's functioning well, interacting, but then all of a sudden the dominant player starts cutting back, that's when you know to really look carefully, because other things equal, like this is not, they're probably not doing something that is profit maximizing, except if they then essentially, have marginalized or eliminated their business partner. And I think we're going to see more of that because that's probably the most successful angle on the litigation as well.
All right, let's give it up for Doha, Adam, Austin, and Jason. Thank you very much. This was a great discussion.